Hey, good afternoon, everyone, and welcome to this webinar, the first in our Ask the Investigator series. And today we are going to be talking about workplace policies and how the language in those policies can sometimes cause confusion when you are conducting your investigation. So today we want to walk you through some of the problematic language that we have seen and encountered in various investigations that we've done, and give you some tips on how to clarify your policies, make sure that you have the right language in there, and that ultimately you are making life as stress-free and efficient as possible as you go through the investigation process. With me this morning is my associate, Joshua
Good
Ghatak.
afternoon.
And Josh and I will be taking you through the materials, and we will be answering your questions at the end. As per the title of this webinar series, there will be a lot of time allocated so that you can ask the investigator your questions, and we will do our best to give you the guidance that you're looking for. Again, this is the first in our monthly series, so do stay tuned for the dates and topics of next month's webinar. In addition, we do have workplace investigation training courses, and we do have some room in our October training seminar. That's a 2-day workplace investigation 101 seminar. So if you are looking to be trained or to get training for your staff so that they feel more confident going through the investigation process, we would be happy to have you join us at our October session, and I'll provide you with a link in the chat function. So turning now just quickly to those housekeeping notes. In terms of asking questions today, Josh and I will be taking those questions from the chat function. So if you can just make sure that you direct your question to everyone, then we'll be checking that feed, and we'll make sure that we answer your questions at the end of today's presentation. So as those questions come up during the course of the webinar today, please do direct them into that chat function, and Josh and I will make sure that we address those on the back end. I've included a link in that chat function to that would take you to our schedule of workplace investigation training events for the months ahead. I encourage you to take a look at that material, and please do send us an email to get some more information. So with those housekeeping notes aside, we're happy to jump into today's presentation on workplace investigation policies.
So one of the first things that we're going to deal with today is the body of an investigation policy and what it looks like. It can be effectively broken down into two components, the procedural and the substantive. And those will be the two items that we really focus on today broadly. With respect to the procedural, that's what we'll deal with first and to kick off most of the webinar. So some of the common things we see in policies are the reporting procedures, how a complaint is formalized and how it is submitted to management. And obviously timelines are very important. And that's going to be the emphasis of really the next few slides, and how these timelines can cause undue stress for the employer and for management representatives when an investigation kicks off and potentially it's delayed. There's a delay in getting witnesses organized, in the provision of documents, and simply kind of failing to see the complexity of an investigation at the outset. So what we'll really focus on is how those timelines can hinder and cause frustration for individuals who are both, whether that's a complainant or the respondent or just other participants even aside from the business representatives. And then we'll also talk a bit about expectations of confidentiality. One of the main questions we often receive in our investigations from participants is, what's my access to the report? Do I get a copy? When do I get a copy? What does a copy look like? And so all of those are common questions that we see and we field, that can be addressed in a policy. And our goal today is to provide you with some advice as to how you can set expectations of confidentiality, how you can set expectations on timelines and the process of an investigation. Because by setting clear and reasonable timelines, you automatically create an investigation process that is easier to follow and that people will not become frustrated by. And that's a key thing that we often see, is that we see investigation participants who become frustrated with the process. And that's where we can help you devise a policy or communications that address those issues. And the second part of the webinar today will focus on the substantive. And that will really deal with the resolution of complaints and how definitions, for example, of something like workplace harassment, how your definitions in a policy can impact the actual findings of an investigator like ourselves. So turning to the procedural issues to start. As I said, the focus here is really on creating expectations. And what we want to create expectations are reasonable expectations. That starts with timelines. When will something be done by? When will something be provided by? When will I have a chance to say my piece? So the goal in creating what we want to create really is flexible or employer discretionary timelines, and timelines that recognize the complexity of the investigation at the outset.
And I think Josh, too, one of the things that we see is that oftentimes with policy, they're crafted, by with individuals who are well informed and well intentioned, but not necessarily with that real world experience under their belt, right? And so what you're trying to do is, oftentimes we see at the outset, is how do we create a policy that creates fairness for the parties involved? And that's where timelines come in, because I think ultimately what's guiding this is we want to provide predictability for the parties. We want them to know that things are going to move along. And
Yeah.
so in theory, it seems like a good idea to have definitive timelines attached to these various steps. But then in reality, what you and I find, conducting these investigations, is that when you have a strict timeline, that doesn't really consider just all the complexities that I think you've already touched on
Yeah.
when it comes
And
to these complaints.
and
And you might have,
it can even be so simple as just like when a witness is available to have an interview. We see just interview dates or simple availability delayed. And that, if you miss one timeline, you've now impacted your ability to meet the rest of them. And it can start so early in the process, or it can start late, and that's kind of what we're getting at here, is the complexity and all the procedural or individual items that can arise in this process. By creating a timeline of 10 days or whatever number of days or weeks, that timeline in no way envisions what the reality and the procedural aspects of an investigation actually look like.
and yeah, that's a good point, because when we say investigation, it almost implies or seems like we're describing something that's homogeneous, right? Like they just look a certain way, but they don't, right? Like you have
No.
varying degrees of complexity, and so one investigation that we just concluded for a college involved almost a dozen complainants. Some were faculty, some were students, and in that situation, the uh, the original complaint that came in from the I'll call it the primary complainant, the faculty member, that complaint was just dozens of pages long, and was was all over the place, frankly. And so it didn't. Some of the allegations in there didn't even relate to the respondent. They actually related to another individual. So had the college taken that document and just said, you know what, our policy requires us to hand over the written complaint to the responding party within a certain period of time, that would have created a lot of confusion, because that respondent would have got this document, would have had a whole lot, but bunch of concerns in terms of, you know, how does any of this relate to me? Some of this is repetitive. Some of this doesn't, the way that it's been described doesn't even sound like harassment. And if you just blindly follow the policy, then you can end up creating confusion and a lot of additional and unnecessary complexity to what's already a stressful situation. So,
Yeah.
yeah, so I think having I think the word used, flexibility, having that flexibility in there to do what makes sense, based on the complexity of what's in front of you, is what we advocate for.
Yeah, that's right. I think it sounds good at, when drafting a policy that uh, everything will be consistent for each and every case or complaint, that everyone will, submit their complaint by X days and will have a particularized document shortly thereafter, and it will be provided to the responding party within a week. But as you said, and as we've experienced, that a complaint can can involve 10, 12 people. It can involve different levels of the organization, and it can span months, years of conduct that someone feels has gone unreported. So trying to unpack that all within the rigid confines of a concrete deadline, it's just simply not possible in most instances. And so providing or having a policy that envisions the flexibility based on a case by case basis, right? We want an investigation that's tailored to each complaint, that is done comprehensively, and collects the documents, shows that it's been fully investigated. That is the type of product or report that an employer can stand by. Trying to force yourself into meeting hard deadlines, just simply doesn't align with that type of process in most cases.
Right.
And so these are kind of a list of the problems and solutions that we identify. Is provide within the policy, we advocate for to try and provide greater discretion to the employer, and that better recognizes the complexity of an investigation, as we've said. um, Having timelines that are dictated by the complexity of the investigation, or the availability of certain individuals. That is those are the goalposts that an employer can much more easily function within and create a sense of fairness and certainty for the participants. So identifying those items, expressly identifying them in the policy as fluid or subject to the investigation is something we strongly support, rather than saying within this number of days.
Right. And I think it's
And
like, and it comes down to, I think, communication, right? Like if we look at that last bullet point on the
fundamentally,
slide, yeah, I think oftentimes the parties to an investigation, they're obviously in a difficult position to begin with, right? Somebody's making serious allegations against another individual. Both parties are feeling a degree of stress, and so there's always this, this pressure from the parties, and just on the part of the employer to let's resolve this as quickly as we can, and but you have to go through the process, right? Like that's just important in terms of reaching a conclusion and having an investigation process that has integrity to begin with. But I think in the midst of that stress and in the midst of that pressure, I think it really comes down to folks just want to know like what's happening with the
yeah,
investigation. And I
they're
think
just curious. Yeah,
yeah,
where
like
where do we
where do we
stand?
stand there? Like what's happening? Like,
Yeah,
and so I think if you have in the policy, if you focus on communication and saying, we're going to give you an update on a regular basis, I feel like that takes the air out of the balloon, if that makes sense. Like it just
yeah,
kind of takes that pressure off, and folks know than where they stand. So I think no matter what the circumstance, if it's if you got 10 complainants and 2 respondents, or if it's just just 2 or 3 parties and witnesses, in each of those scenarios, providing the participants, the parties, we're talking about the complainant and the respondent, providing them with a regular, whether it's a weekly or a bi-weekly update. I think that goes a long way to letting them know that, hey, we haven't forgotten about you, that
Yeah.
work is being done, even though you've already met with the investigator, and uh, no one's come back to you for more information. That doesn't mean that nothing's being done. Like the investigation is progressing, and I think that's an important element of
Yeah.
of a policy.
And I find it reflects well on employers just because it shows a level of attentiveness to and kind of care or compassion even for the individuals involved that, you know, everyone no, I guess nobody really wants to be involved in a workplace investigation, but when you're in it, it's important that you feel like it's being treated fairly and being uh, professionally operated or
Mhm.
conducted,
Right.
and rather than being left in the dark after your interview, or having no updates about are we at the interview stage, are we at the report writing stage, kind of um, having no idea of what that concept looks like and having
Hmm.
no information about it. I think anyone would really find frustrating and kind of concerning. And I would say it's almost more common for the responding party when
Yeah.
because they feel like they're, being, obviously the complaint is against them. And so
Right.
they want to know that they're being treated fairly and are involved in the process.
Exactly. Okay. So I think that again, we do want to leave a lot of time for Q&A at the end of this. So uh, we'll transition over to the substantive issues now. And before you uh, e- oftentimes are even faced with a complaint, a formal complaint of harassment, or whatever the case might be, many policies will have a dispute resolution mechanism, and the expectation is that employees and those parties involved, that they'll take steps to resolve these conflicts informally before they escalate to a formal complaint. And 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 that's good. That's what you want to encourage, right? Is to empower individuals to be able to go to the colleague and say, hey, look, what was said here or what was done is I have a problem with, and give them that ability to get to resolve that problematic incident. But one of the things that gets overlooked in that goal to empower folks is that sometimes where individuals that are first presented with that, or kind of directed to, hey, go solve the problem yourself, when they're first presented with that, they often and they don't feel that there's a safe way for them to report misconduct. Those two things in tandem can lead to a really dangerous situation where you get incidents that are not being reported, or that are being underreported. And oftentimes the cases that we get called in to look at, it's where you have these issues that have been taking place for a number of years, and there's maybe rumors of bad behavior and problematic things happening in the workplace, but nobody actually comes forward and files a written complaint. And so HR, they kind of hear the rumor, but HR has a dozen or more different things to balance. You just don't have the time to proactively go and look into these things. And so, maybe weeks or months or maybe even years go by, then you get the complaint. And it's a much more complex issue now that involves, multiple parties, that maybe spans, months, if not years of bad behavior. And you just haven't had the ability to nip this thing in the bud. And so that's what you want to be mindful of. I think especially in situations where you have a power imbalance, like where we see this a lot is in the university and college context, right? Like where you have students who are expected to bring a complaint forward or a concern forward against their professor. Well, a student's not, I mean, the evidence bears this out. They just don't feel comfortable bringing a concern forward and resolving that with a professor if that's the individual who's been, berating them and intimidating them. Uh, there's just too much of a power imbalance there, and then what you end up with are these problematic events that fester and then become turn into a major investigation a couple years down the road. So looking at your policies then, and and in as much as you want to empower individuals to resolve conflict, you also want to make sure that you're supporting them and saying, look, uh, here is a safe person that you can go to discuss this. Here is a process that is very easy and accessible for you to file a complaint and to get it resolved if for whatever reason you're not comfortable dealing with this in an informal way. And to the second bullet point on that slide, I think that's especially important, where you have the alleged harasser is the person's manager, right, or supervisor. Again, it kind of goes back to that power imbalance, and you need as an employee a safe place to go, and so it's really important that a that a policy can recognize that and provide a solution for that, whether that's in-house or using a third party, providing a safe workplace where the employee has that assurance that, yeah, my company has this policy, they care about a healthy workplace, and here is a mechanism that I can use to bring my complaints forward. And that brings us to the definitions. I don't want to spend a lot of time on the definitions, but I do want to highlight just the fact that the definitions are important, because when you are investigating a complaint, there may be problematic behavior that, as the investigator, you're presented with, and you found like these troubling things happened. But how, for example, harassment is defined in a policy will dictate what your conclusion is going to be. And so if we look at harassment under the first bullet point there, option 1, harassment can be defined as engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably known to be unwelcomed. Some definitions will add to that to say that it could be a single incident, if serious enough, may also constitute harassment. But you have option 1 there, where they're discussing, for the most part, a pattern of behavior. Option 2 is harassment means any action, conduct, or comment, including that of a sexual nature, that can reasonably be expected to cause offense, humiliation, or other physical or psychological injury or illness to an employee, including a prescribed action, conduct, or comment. So you see, one of the main differences in these two definitions is one is focused on a vexatious pattern of behavior. The other is really focused on any single incident that could result in humiliation to the opposite party. So if you're then dealing with a situation where your policy has defines harassment as option 1, but you're just dealing with a single incident, then that that will dictate the conclusion that you come to. So let's just say the example is someone called their coworker an idiot at a meeting, and it's just the one comment. Well, it's just the one comment, so it's not a pattern of behavior, and likely even if your policy had that additional language that said, if the conduct is serious enough, a single incident could constitute harassment. Again, calling someone an idiot at a team meeting likely is not going to, on the continuum of bad behavior, is not going to meet that threshold of harassment. But you can see, in that scenario, just how important the definitions are, and how you then have to interact with the facts that you are working with, and then fitting those into the definitions in your workplace policy. Another issue here with definitions, and it's actually a really big one, is the scope of your policies, right? So when it comes to harassment, and I'll just go back to the definitions in front of us there. When it comes to harassment, you can see in that first definition, it's talking about vexatious behavior against a worker in a workplace. And And so that right there, speaks, it engages the scope of the policy. It's not just, and any behavior by anyone. Like, it's specifically defined as applying to, workers, and not even just like workers, no matter where they may be. It's workers in a workplace. And so then, if you, as the investigator, are, looking at this behavior, if you then have a scenario where you have employees who are, off duty and just, at a social function, maybe they are, um, at a private barbecue, just because it involves, and there's a disagreement that arises, just because there's a disagreement between two people who happen to work at the same company, that doesn't trigger an obligation on the part of the employer to investigate this issue and to, take the steps that they normally would had it been a workplace issue, right? So, you can see that the scope of the policy is often dealt with, in its own clause, in terms of, the that issue being dealt with, usually in the preamble, or at the beginning of a policy document, but it can also be dealt with in terms of the definitions themselves. Another one that, we would like to highlight is bullying. So sometimes bullying is defined as, repeated, behavior, and, really speaking to, a power imbalance, right? That this is something that a manager or a supervisor is doing to an employee. And so again, is that that power imbalance where you have, a junior staff against a more senior staff. But so if that's how bullying is defined, if you're then in a situation where you have a worker who is being belligerent and insolent and, in effect, bullying a manager, what do you do with that? How does that behavior get addressed, within your policy? It could be the case that, if the policy is defined, if bullying is defined, in the way that I described, where it is specifically defined as, being, by a manager towards a subordinate, then you've got a problem, right? Like, you have problematic conduct, doesn't fit within the definition of bullying. It may still be harassment, so it may fit like some other definition, but you then have problematic behavior that just doesn't fit nicely, right, within a category of misconduct, that makes it easy for you to then make a finding. So those are just some examples in terms of how these definitions, come into play, and why it's so important to look at your policy, and to, have someone experienced to look at the policy and look for ways that you can, tidy up the language, so that you have language that that works for you and that's consistent with the legal obligations in your specific jurisdiction. So as I promised, we wanted to leave a lot of time today for to answer your questions, and so we will turn to your questions now for the next 30 minutes. And so, Josh, I don't know if any questions have come through in the chat function, but happy to transition to that Q&A now. Yeah.
We don't have questions yet, so I urge everyone to don't be shy and please use the chat if you have simple or complex. That is what we're here to answer. But to get things kind of kicked off anyways, one of the main questions that we always get, and what Dorian was, just alluding to, is why is the definition of harassment important? And comparing it against those examples that we've seen.
Yeah, so that's a great question, Josh. Why is the definition of harassment important? So again, it typically, harassment is typically defined as, engaging in a course of vexatious comment or conduct against a worker that is known or ought reasonably be known to be unwelcomed. So it speaks to, that pattern of behavior. So if you are, as an investigator, then dealing with a single incident, then, unless that incident is serious enough to trigger a finding of harassment, your policy definition is going to require you to look for a pattern of behavior. So if we look at the example of, whether it's a manager or a colleague in the context of a team meeting, making the comment that, hey, somebody else's idea was stupid. Obviously that comment would cause some humiliation to the receiving party. But if it just happened once, then that wouldn't fit within the definition of um, a course, right, of vexatious comment or conduct. If you, however, have that incident, or a version of it happens again, where you have someone really just being dismissive of someone's ideas, kind of whispering out loud, a negative comment, and being critical of that individual, then over time, then you can see, despite the fact that we're talking about behavior that is arguably on the lower end of the continuum of bad behavior, you then have this behavior repeated over time, and then that would that in that scenario, it should be known, or ought reasonably be known to be unwelcomed. And so that's where over time that behavior could fit within the definition and constitute harassment. So the definitions are very important, both in terms of, I would say, first of all, making findings, but then also in terms of setting out the scope of your policy, right? Like many workplace policies are designed to address misconduct or alleged misconduct that occurs in the workplace. The employer, generally speaking, isn't interested in monitoring what folks are doing outside of work. And so to the extent that you have two guys at a barbecue who have a disagreement, and that escalates into an argument or dispute of some sort, that doesn't automatically trigger a workplace issue, unless the scope of your policy or the way that you've defined harassment leaves it open to it being something that could give rise to a workplace complaint. So we have seen situations where you have conduct between two workers, again, outside of work, but then that disagreement finds its way into the workplace because one worker then starts agitating the other worker. So again, the original dispute occurs outside of work, does not give rise to a workplace complaint or any obligation on the part of the employer to investigate that complaint. But then the fallout, I would say, from that disagreement, you have one worker who is intimidating another worker at work, really being agitated over that original dispute. Well, now that behavior is in the workplace. Now you've got these two workers kind of going at it, and then workplace gossip that surrounds that, and then you create that nexus between the off-duty conduct, bringing it into the workplace, and triggering now a workplace investigation. So it's not to say that off-duty conduct can never be something that finds its way into the employer's responsibility to investigate, but you want to make sure that your policy makes it clear, so that as a internal HR person, you can go through that checklist, and you can determine does this trigger a duty to investigate. And that's actually one of the things that we talk about in our one of the things that we lead off with in our 2-day workplace investigation training course is what triggers an investigation. Not every allegation requires an employer to jump into a full-blown investigation or a fact finding. And so we try to walk attendees through how do you identify at a first step, does the misconduct in question trigger an investigation? And then from there, we walk you through how to set up that investigation, and then how to go about conducting it.
And then in terms of one of the key things we've emphasized today is a pattern of misconduct versus a single incident. A common question that we get is, when does that single incident, whether it's harassment or maybe something like sexual harassment, can that support discipline, like a termination for cause? At what threshold or severity level does that single incident need to rise for discipline?
Yeah, it's a great question that we get asked all the time, and arises, right? Like when you have misconduct, the employer wants to know, like,
What can I do?
what can I do about this? Yeah.
Yeah.
And what are my obligations? Because you may be faced with a case where you've got a long service employee or someone that's otherwise a good worker, but they do something that's really egregious, and you then have to weigh, from a business perspective, how you feel about this employee, but then also weigh the other um, the other perspectives and obligations as well, in terms of, what are, how does, this impact, or how does this misconduct impact my obligation to provide a workplace that's free of violence and harassment? What kind of message am I sending to my employees if we don't take a serious stand here? And so these are never easy questions, right, to unpack. But if the question is, to what extent can a single incident then give rise to termination for just cause? There's a case of recently of Render and ThyssenKrupp, where you had a manager approach a female subordinate, and he he kind of got down into like a football stance. He put his head like really close to her breasts, uh, and then kind of tapped her on the bum and said, "All right, good game," or something like that. So again, like just kind of mimicking, I guess, being on the offensive line, I suppose, like in a football game. But the employee was obviously really upset by that, confused, humiliated, and um, and the other, and and one of the other problematic aspects here is that the manager actually went around to other coworkers and said, I slapped her bum with my right hand. If you pay me $10, I'll let you shake this hand that touched her bum, kind of thing. So so not only did he engage in that behavior, but then made light of what he had done. So it was a single incident in what was otherwise a long and unblemished career, but in that case, the employer decided to terminate for just cause, and that termination was upheld. So we're talking about a long service employee, a single incident of sexual harassment, but the court found that it was serious enough. It was just a fundamental breach of the employment relationship, that there was a breakdown in trust there, and that the employer, in looking at all of the circumstances, when you look at the the incident itself, considering the service of the employee, but then looking at the harm or potential harm in the workplace if you don't discipline or terminate, in balancing out those factors, the proportional or the decision here to let him go, that was proportional to the harm that was caused. So these are never easy questions, but certainly a single incident that is serious enough can definitely support a termination for cause. But it makes it very important that you, as the employer, you have your facts right, that you've done a proper investigation, and that you, at the end of the day, you have a set of facts that you could then rely on to make the appropriate decision, whatever that might be.
Right. Yeah. I think it's all about kind of creating that record or basis for your next for your disciplinary decision.
Right.
And then a common question we get for employers who are unionized is, what is the role of the union in an investigation, and how can a policy incorporate that or envision that? That's something we see with our unionized employers.
Right. So in a unionized context, Josh, the employee, by virtue of the collective agreement, they would have a right to representation, and usually that's in the context of a meeting or something that could lead to discipline, but could always, but that's that right to representation is usually read really very broadly by arbitrators, and so would include the ability to have a support person present at a interview in the context of an
just like we have.
investigation.
Yeah.
That's right. So so in the context of an investigation, then the in the employees, the policy might might indicate that the witness has a right to union representation if they choose. So again, it's not an obligation to have someone there. We have certainly had instances where folks that we were meeting with were represented and had the right to union representation, but did not want to have a representative there. So it's the employee's choice at the end of the day, but you can have a policy that just, makes it clear that the employee does have the ability to have a support person there. And then that takes me to the next point, which is that is the role of the union, is to act as a support person. So they're not there to advocate for the employee. They're not there to interrupt or interfere with the investigation. At the end of the day, the investigator, whether we're talking about someone in-house or an external investigator, the employer or the investigator has the right to get the information that they need directly from the witness without interruption. So the union is just there to support that person, be physically present, maybe take notes, and but essentially not interrupt and interfere with the investigation. So that's the that's the role of the union, is to really act in that supportive role.
And
And
then I would also, I guess from that I'd ask, to flip the scenario for non-unionized employers, what is the expectation for witnesses or complainants or respondents to participate in the investigation process? Because we often see people hesitant to engage. So can you speak to the expectations of just a normal employee in a non-unionized setting?
yeah, so I think the question is, what is the obligation? What is the obligation of an employee to cooperate
To
with
cooperate, participate,
to cooperate with an employer's investigation? So yeah, what is the obligation of an employee to cooperate with an employer's investigation? And that the investigation is something that the employer is required to do, right? So this is part of the employer's obligation, under legislation, to look into allegations of misconduct and determine, whether or not there's anything, problematic happening here that would, impair and undermine, the employer providing a safe workplace that, that's free from violence, harassment, and discrimination. So the employer is following, like, it's this legislative obligation, and the employee then has a corresponding duty to cooperate with that with the employer's investigation and to assist in that obligation. So they certainly then can't set themselves up in a position where they're frustrating the investigation. But that's sometimes what happens with in the context of an investigation, is you'll have that could be a party, or it could be a witness that says, what, I know I've raised this complaint,
Uncooperative.
but yeah, I just don't want
Yeah.
to I just don't
I
want to
don't
meet with
want
the
to pursue it anymore. Yeah.
I don't want to pursue it anymore. Or if it's a witness, I'd rather not get involved,
Yeah.
and I'd like to sit on the sidelines. And it's then up to the employer then to look at, well, what do they do with that, right? So certainly you can look at one option, which is, not meeting with the individual, and acceding to that request on their part, and seeing if you're then able to collect the information that you need to discharge that obligation, right? To get at all of the relevant evidence and to make a finding of fact. uh, you might be able to do that in certain circumstances and accommodate them. In other cases, you may not be able to. And even if and even if you are able to, sometimes you don't want to, because you don't want to set a precedent of folks just thinking that this is a voluntary exercise. Again, the obligation there is for the employee to cooperate, and there are cases out there where employees have been disciplined and dismissed for frustrating an employer's investigation. So ultimately, the employer can insist that the party or the employee witness participate in the investigation, meet with the investigator, and give their evidence, and in order for the employer to satisfy its mandate under applicable legislation. So yeah, so push come to shove, the employer can insist on that participation.
Yeah, exactly. And then what are some of the key documents? One of the points that we had raised earlier was the provision of documents, but in our investigations, what do you identify or often rely upon as key documents? in
so much
terms of
of
making your findings.
so much of communication these days is electronic, which is, I would
There's a
say, different from, even if I look back, 10 years or so, like I think things were a lot different, 10 years ago. But yeah, but especially in the last, in the last 8 to 10 years, there's just, the volume of correspondence between individuals is, text message and email, and even between coworkers, right? Like coworkers obviously have email channels, but they'll still text, or
yeah.
communicate on other social media platforms, and so that information becomes key when we are investigating complaints, and oftentimes making credibility assessments. You know those real-time communications between the parties give you some insight into the dynamic, right? They obviously capture what was said,
Yeah.
and then you're able to then put those communications to the individuals to get an explanation. So I would say the text messages and emails really stand out as being key documents, especially when you don't have any other witnesses. And if you have a sexual harassment an allegation of sexual harassment, and you really only have these two individuals, there are no other witnesses that can be of great assistance. Having these text messages, and emails, maybe even logs of phone calls, like those are the things that can really help you as an investigator make a sound credibility assessment in a given case.
Yeah, I would agree. We see so much, so many examples of text messages or screenshots of, internal business processes, or, video evidence is an example of other things we've received that, it really can become, quite onerous and labor intensive
Mhm.
in terms of reviewing, coming to conclusions, corroborating those documents against verbal evidence that we receive. Um, you know, all that to give an example of of how timelines, need to envision that and account for that flexibility.
That's right.
And then, um, to talk about policy language specifically, to really put pen to paper, what are examples of things not to include, in a policy, uh, in an investigation policy? What would you advise against, rather than for?
I would say some of the elements of a policy that you definitely want to avoid would be, number one, strict timelines, right? So having a strict timeline in terms of handing over the written complaint to a responding party, that's problematic from the perspective of, you're potentially handing over something that is not a nice, neat,
Yes, not
cogent
refined, fully
document, is
loaded.
not refined exactly.
Yeah.
And so um, I actually can't think of a situation where we got a complaint from a complainant that captured all of the things that they were complaining of.
No.
So even when they take the time to put the complaint in writing,
Yeah.
even where it is well written, it doesn't necessarily capture all of the things that they're complaining about. So you think about this from an investigation standpoint. If you just take that document and you hand it over to the responding party, the respondent is not going to know that. The respondent is going to think, okay, here are
This
the
is
10
it.
things.
Yeah.
Here are the 10 things that this person is complaining of. And when you then start the investigation and you meet with the complainant, because that's the critical first step of every investigation, meet with the complainant and flesh out their complaint. If you then, after that investigation, there are 12 things that this person is complaining of, not 10, and you then give the responding party a copy of this new document that has the 10 things that the complainant is complaining of, well, what's their reaction going to be? Understandably, they're going to say, well, this person's changing their story. Like, here's this document that you've given me now. Here's the original document. Obviously, these things have changed, or these details have changed. And then from the get-go, all that you've accomplished is to create confusion, and create confusion in the investigation process. Create some doubts on the part of the responding party in terms of how how credible is this complaint, and maybe opens up some avenues for them to ultimately attack the complainant, the legitimacy of the complaint, and depending on how things unfold, maybe the investigation itself, right? So I would say you want to stay away from strict timelines, and that applies to both the point in time in which you hand over a written complaint to the responding party, to the overall timeline for completing the investigation. What you want is to instead have language in there that indicates that the responding party will be notified of an investigation within a set period of time, so they can be made aware that we've received this complaint, and here are the steps that we are undertaking. But you don't provide a written copy of the complaint until you have something that is in final form.
Mm-hmm.
And
One of the steps we often take is to, formalize the complaint and then have it confirmed by the complainant. Are you comfortable with this? Have we accurately summarized?
right.
Is this all you have to say?
Exactly. Yeah, no, that's a key starting point, because you want to make sure that from the get-go, as a third-party investigator, you you've captured in a comprehensive way the allegations, and you want to make sure that uh, those allegations fit within your mandate, right? So you want to be able to go back to the employer and say, look, here's what you've retained me to do. I just want to confirm, that I, my mandate matches up with these, 12 allegations that the complainant has made. There may be some things in there that don't fall within the
Mm-hmm.
mandate. So you definitely want to be clear on that before you move forward. I would say just like a final point on policies too is, we had a case recently where it wasn't the employer's policies, but it was actually the union's policies that created confusion and ultimately led to some conflict in the workplace. And it was a situation where the union, uh, they have an obligation to represent bargaining unit members, and they often find themselves representing both sides to a workplace investigation. So in this case, you got the union, one individual from the union representing the complainant to a harassment complaint, another representative representing the respondent to a harassment complaint. In the context of that investigation, the union rep who was representing the respondent says to the complainant's rep, "Hey, can you give me your notes?" And asked for those notes, apparently before this investigation had wrapped up, and that triggered a whole series of events where the complainant's rep said, "Well, that's completely inappropriate, and and you shouldn't be asking for that." And again, so it triggers a whole series of events, but really it all stemmed from the union not having clear policies in terms of, here are the rules of union officers, and specifically when it comes to you know representing parties to a workplace investigation. Here are the steps that you need to follow. Here's the procedure that's going to unfold, and here's when it's appropriate to maybe put all the notes right in one comprehensive file for use down the road. But it was the union's policies that created confusion. So sometimes, as the employer in a unionized context, um, you would never think to be alert to anyone else's policies but your own. But in a unionized context, this is an example of where that that organization's policies came into play. So again, those are just some insights that we have picked up along the way that folks might benefit from, and that they might want to look to ensure that to the extent that the union is a partner in the workplace, right? The collective agreement is between the union and the employer. They both have to ensure that they have policies that are to some extent in harmony with each other, or at least not creating conflict for each other.
And then finally, one of the things we didn't get to touch on too much, but an important question is, particularly from the employer standpoint, is what is my obligation to produce the report, an investigator's final report, and should my policy address that topic?
typically the employer would not have an obligation to produce the investigation report. And generally speaking, employers want to reserve that flexibility for themselves because in the context of an investigation, you are collecting an enormous amount of information. You are meeting with uh, many different individuals. So from the perspective of just maintaining confidentiality of all those who participated in the investigation, as an employer, you might want to just report back to the parties on, here are our conclusions, right? Here are the 12 things that were complained of. On each of these 12 things, here are our findings. The behaviors in question either did or did not violate any applicable policy. To produce the whole report, again, runs into questions about how are you going to maintain the in confidence, the names of the other folks who
Names, the
participated
evidence, yeah,
and
the
and the
process.
evidence they provided.
Yeah.
The other issue here is you may very well receive in this report or capture in this report information that's frankly like not helpful to you. So if you then create this obligation to just hand over this document to the other side, you're essentially assisting someone in advancing, what could be, a case of discrimination or harassment, whatever that might be, against you. So, so certainly, you have an interest in preserving confidentiality. You also have an interest in trying to limit the liability, from the incident in question. And so the better approach is to report back to the parties on your conclusions, but not create an obligation to hand over the investigation report. Now, if there is formal litigation that that ensues, another question might be, can the employer maintain privilege in the investigation
Mm.
report? Like, is the investigation report likely to be, ordered, produced to the other party? And generally speaking, it's very difficult to assert privilege over an investigation report. Sometimes employers will retain a lawyer to conduct the investigation, and um, the lawyer will conduct the investigation and provide advice to the employer, based on the findings of that report. And so that gives you a little bit of a shield to at least try to assert solicitor client privilege or litigation
Mhm.
privilege over the document. But at the end of the day, like, that isn't something that employers should rely on, more likely than not. And what we've seen certainly from arbitrators is that they will order that the investigation report be produced. But again, that's after the parties have started formal legal proceedings and you're into the litigation process. It's within that context that it gets order produced. At the In the early stages, you as the employer, again, more likely than not, you're going to want to maintain control over that
Yeah.
document, and not create this obligation to produce it. So I don't see any other questions that have come through, Josh. And so
No.
I want to thank everyone for joining us today and participating. We hope that the discussion was helpful to you. Um, for those who maybe joined us a little bit later or after the introductions, we discussed the fact that our firm is a client-focused employment law firm. We're based in Toronto, but we do work across North America, and we are focused on specialized in conducting investigations, and providing training and advice to help employers build healthy workplaces. In doing that, we're happy to roll out this series of monthly webinars called Ask the Investigator, and it gives you an opportunity um, to for us to unpack a topic for you and leave a lot of time at the end of the presentation for Q&A for you to get the answers that you need to any complex issues that you might be wrestling with. So that's a series of monthly webinars, and we certainly will reach out and provide you with details of the events that are to follow. We also have a series of training sessions that are held monthly from October through June. So I've included a link in the chat function. If you visit that link, you can see the dates of some upcoming seminars. So if you're looking at giving your staff the confidence to conduct an investigation and tackle some of these difficult issues, and just feel comfortable, responding to a harassment complaint. We strongly advise you to register for the Workplace Investigation 101 course. It's a 2-day course, and takes you through from beginning to end, how to respond to a complaint, and then how to investigate that, and ultimately make findings and draft a report. So we do have, I believe, a handful of spaces still available for our October session, but you can certainly contact us to learn more about that. And then finally, we're happy to announce the launch of our Ask the Investigator podcast. So that's a weekly podcast where, again, we unpack an investigation question for you in a short, 12 to 15-minute segment, and that's delivered on the platform of your choice. So we will again reach out to let you know once that has been published, and we hope that you would subscribe, that you would be an active listener, and that you would help us promote the podcast to others who can benefit from this information. So again, thank you for joining us, Josh. Thank you
Thank you.
for presenting today, and we wish everyone all the best going forward. If you have any questions that you'd like us to unpack in a future webinar or a podcast, please do send us an email at info@persaudemploymentlaw.com, and we would be happy to take that into consideration, and prepare a session on that topic. Okay. Thanks very much, everyone.
Thank
Take
you.
care.